2 weeks ago, I wrote to the Ministry of Justice. I referred to my experience in one of the previous videos. I'd actually written to Dominic Raab in his capacity as Justice Secretary, but frustratingly, that then was an automated message saying that he only took constituency concerns. Would have been good if that message had come up front, rather than being a public email for general concerns in his capacity. Anyway, I was redirected to the Ministry of Justice, so I redirected the message there, and I had to condense it to a shorter form of what I'd written because it was a number of things that I wanted to address. Anyway, I've got a response which I'm semi surprised by um, because I just didn't entirely expect them to respond. But anyway, I'm not going to read out all of it. It's quite extensive, which is good. That's better than it simply being dismissive. But before I get into this, well, firstly, what I'm going to do, and I appreciate this isn't the most exciting video format subject, but I really, really believe it's very important. I've made no secret of the fact that law and justice, crime and justice, is one of the issues I feel strongest about domestically. Maybe the number one issue, in fact. Um, it's just such a powerfully emotive subject in this country. So rather than talk about the whole thing, because I raised a number of questions and I've got a number of responses, I'm going to do it segment by segment, so I'll make separate videos for each segment. So bear with me. Like I say, it's not the most glamorous subject. It is what it is, but I do think it's very important, and I'm going to put a link if I can to the response. I'm not sure if I can do it, but I'll try. I'll try to do the link so people can read this for themselves. I sent this, like I say, it would have been about 3 weeks ago, maybe a month ago. I can't remember exactly, but anyway, this is it. This is the response I've got. So I'm going to read out the first segment and the first response. And because of its length, I'm going to divide this up. But anyway, here it goes. So this is dated the 2nd of September, so it was sent yesterday. Dear Mr. Hazlett, thank you for your emails of 11th of August. There we go, 11th of August to the Lord Chancellor regarding the subject of offences committed by teenagers. As a government official, I have been asked to respond. I also acknowledge your email of the 17th of August. Um, this must have been the one that I sent on top of. This must have been the one I sent directly to the MOD because, like I say, the one I sent to RAB was um, redirected. I'm sorry to read of your own family's experience of crime. Nobody should have to leave their home as a result of criminal activity. I hope you will be reassured that the youth sentencing framework is designed to ensure that any sentence imposed on a child takes the seriousness of the offence as the starting point. In assessing an appropriate sentence, the court should consider the physical and psychological harm caused to the victim. Well, already there's a problem in that response. What I'd specifically raised was the issue of teenage offenders in this country. As we all know, there's been a lot of reports recently of basically teenage offenders running wild. That's not an attack on all teenagers. If you're a young person and you're watching this, I'm not vilifying teenagers in general, but there is a problem. There is. And that's what I was raising. But therein is a problem. A 16-year-old is not a child. The government itself, in England and Wales, legally, 10 is the age of criminal responsibility. 10. So it's kind of a contradiction to call a 16 or 17-year-old a child in this context. I think they need to make their mind up. Either they are old enough to be criminally liable or they're a child. I don't think you could say, well, this 16-year-old is a child, but we're holding them criminally responsible. I think they should be, by the way, but I really object to the use of the term child here. I think to the minds of the general public, a 16-year-old or a 17-year-old is not a child. They're a teenager. Anyway, you asked several specific questions in your correspondence, and I've responded to each individual topic below. So that's something. It's better than a dismissive response. Right. By the way, my own experience, 20 years ago, my family lived in an inner city area of Sunderland. And basically, we got a rough time from local youths because we stood out. We were outsiders. We come from Northern Ireland. It was a very, very unpleasant experience, but it shaped my whole philosophy on crime and justice. So that's just the background to that. Although it was a long time ago, I don't think I'll ever forget that. Okay, so this is the first point that she has, the first question she's responded to. Public accountability of the Sentencing Council and Parole Board. So I'm going to read out the response here and respond to it and give my thoughts on it. I've mentioned the Sentencing Council and the Parole Board in a number of these videos that I've made on law and justice. But anyway, um, this is what they say. You asked about the public accountability of the Sentencing Council and the Parole Board. The Sentencing Council was established in 2010 to promote greater transparency and consistency in sentencing while maintaining the independence of the judiciary. It does this through issuing sentencing guidelines which reflect the legislation set by Parliament and relevant case law. The Council is rightly accountable to Parliament for the delivery of its statutory remit, to the Ministry of Justice Permanent Secretary as its accounting officer, and to ministers for the efficient and proper use of public funds delegated to it. As I hope you will appreciate, the Council is an independent body that decides on its own priorities and work plan for producing guidelines. The Council has published its criteria for developing or revising guidelines, which is available at, and they've given the link. The development or revision of guidelines includes rigorous research and policy and legal investigation, as well as a wide public consultation, including responses from criminal justice professionals, subject matter experts, the Lord Chancellor, and the Justice Select Committee of the House of Commons. It is open, of course, to individuals to approach the Council with their concerns. I have several times, and I didn't like the response. I think they're very self congratulatory. Um, their own website is full of, they actually have a section on misconceptions about justice, and we'll get into that in a second. Regarding the accountability of the parole board, the root and branch review of the parole system was published on 30th of March 2022, announcing a range of reforms to the parole system which will ensure greater emphasis placed on public protection when it comes to the release of the most serious offenders. I mean, that should be a no-brainer in the first place. Reforms will include new powers for ministers to intervene to refuse the release of prisoners who have committed the most serious offences, such as murder and rape, where ministers consider the offender still poses too much of a risk to the public. I should say Dominic Raab spoke out on this himself with the controversial release of Baby P's mother recently. He said that ministers should have more power to block their decisions. The Ministry of Justice is also proposing to change the release test that the parole board must apply by making it clear that the protection of the public must always be the overriding consideration in release decisions. These reforms require primary legislation. In addition, the review contains proposals to increase the number of parole board members with a law enforcement background. I welcome that, such as ex-police officers, to bolster the numbers with frontline experience of tackling crime among the members who make these important assessments about suitability for release, because most of them are out of touch and useless. These reforms will put public protection at the heart of the parole system. The root and branch review also set out proposals for improving the transparency of the parole system and ensuring that victims are properly supported and have their voices heard in the process. In July 2022, we changed the parole board rules to allow public parole hearings where that is in the interest of justice to do so. That was one of the good things that Rab done. I give him credit for that. Okay, so I'm just going to deal with this first response. There was other responses, but it'll be too much for one video. But that's a big one. There's a lot to comment on there. Well, if you have a translator, be my guide. I mean, I understand about probably two-thirds of that. This is typical of our justice system. It's very complex and it's bureaucratic. I get that some of that is inevitable. Justice is a complex matter, but this gets into an issue of language. It gets into an issue of communication with the public. You know, I haven't been a victim of crime recently, but I feel very strongly about the subject now. Victims of serious crime will probably have trained officers to, as first responders, to deal with that. At least you would hope so. That case I mentioned about the mothers in Chorley, Lancashire, assuming that that is the whole story. Um, the police give a different account, but I think more often than not, victims of crime do feel let down. They do feel like they're going up against this monolith. And frankly, this trickle down measures are not good enough. It's like changes happen, but they're small and they're not that significant. Okay, so more people, more of the public get to look into parole hearings, good. Um, but the sort of changes that happen are relatively minor. I honestly think that what really needs to happen is a massive overhaul of the whole system. Um, this point about the Sentencing Council being independent is actually very significant because often we'll hear that, for example, judges have their hands tied and the Sentencing Council simply follows government guidelines. The point is, there's an inherent contradiction here because in our constitutional system, in our democracy, the judiciary is independent from parliament. Now, I understand the need for that because if you have a judiciary that's controlled by the government, then you have a system like you get in single party states, where political opposition can be rounded up and so on. It's not going to happen in Britain. So I understand the need for independence. But here's the problem. The unelected bureaucrats who run these things are just massively out of touch. They do not understand public anger. Okay, they may have to answer to Parliament, as in the case of the Sentencing Council, but she said that there's extensive public consultation. No, there isn't. That's not true. I've looked at their website. There's some public consultation. It's certainly not extensive, and it's not on every crime. I think that there needs to be much, much, much more public consultation. I don't have respect for the parole board and the sentencing council. I don't think their heart's in the right place. I think they're institutionally soft, and I think they live in a bubble. I really do. I would like to see them at least partly elected, something akin to police commissioners. I've said this before, and I'll say it again. If you had the head of the sentencing council elected, and it's not good enough saying, oh well, they're answerable to this. It isn't even Dominic Rabbit's. Um, Let me just go back to the term that was used. It's a junior minister. Let's see. Yeah, to the Ministry of Justice Permanent Secretary as its accounting officer. I mean, that isn't even directly to the Justice Secretary. So I question how much accountability they have. I mean, the fact is, they were created in 2010 supposedly to be more accountable. But how many people, how much of the public even know about the Sentencing Council? I know about it because I feel so strongly about the subject, and I made it my business to find out about them. But, if you ask someone on the street who are the people responsible for setting guidelines or responsible for setting sentencing, they probably say, oh, well, it's MPs. But this is a bit that really bugs me. It does this through issuing sentencing guidelines which reflect the legislation set by Parliament. Um, well, this is an inherent problem. If it's supposed to be independent, but then they're saying, oh, but they're reflecting the legislation set by Parliament. Either they do or they don't. If they do, I think it's a good thing because at least MPs can be elected. And if they're too soft on crime, if the public feel the way I do, they can vote them out of office. I certainly think politicians can be doing a lot more than they are. I don't think it's good enough to say, well, politicians can't have an opinion because then they'd be seen as interfering. Um, Politicians can still raise concerns. They're elected by the public. I mean, as it stands in this country, the legal establishment, judges, parole officers, and so on, they don't have to answer to the public. I think that's wrong. I think it's wrong. I think they can still remain independent whilst being far more answerable to the public. It infuriates me. It really does. I'll just see if I can read the next section. I don't want to make this too long because there's a lot of this to address. Um, I'm going to go forward to one of my other questions because it directly relates to that point. Accountability of individual judges is a long-standing constitutional principle that the judiciary and the government are separate from each other and the judiciary are therefore able to act impartially and free from political motivation or influence. This means that there can be no political process to challenge decisions made by judges. If there is a disagreement with a particular decision, the route is by appealing that decision through the court. I thought that was quite an evasive answer, and this is why. I totally get that elected politicians cannot say, I disagree with that decision and I demand it is overturned. How then, there's contradictions here though, because if people feel that a sentence is unduly lenient, they can ask the Attorney General to refer this to the Court of Appeal. So actually, there is political involvement. So it's a fallacy to say that there should be no political involvement whatsoever. That's clearly, it's clearly ridiculous because yes, there has to be an independence in the sense that you can't have politicians saying this should be the sentence for this crime because it's not MPs sitting in on trials and hearing the evidence and so on. But the idea that there's no crossover, I think, is flawed. And I don't think there should be because I don't trust judges. I don't trust the legal establishment. I think they live in a bubble. I think that there should be more political pressure, quite frankly, without totally interfering. I'm not calling for MPs to say this should be the decision in this case. That is for judges. But at the very least, I think MPs should be able to speak up and say, we're elected by the people are not happy. That's democracy. That is democracy. I mean, what she said here, if there is a disagreement with a particular decision, the route is by appealing that decision through the court. Here's the problem courts don't listen. You know, if you look at a court of law, they'll have an address. Um, they may have an email address, but you know, the chances of actually holding an individual judge to account is next to nil. I think that's wrong. In America, judges are elected, judges are accountable. Um, we have judges in this country I think are a walking disgrace. An example is Richard Mansell, QC of Bradford Crown Court. This guy recently sentenced a teenager to 6 years for killing three people. He was 15 at the time, driving the wrong way down a motorway, killed three people, killed three men, three people. Now, for this, he got 6 years, 3 years in prison, and 3 years on a suspended license. 6 years for three lives. Now, Judge Mansell claimed this wasn't a reflection of their lives and each life is precious. I looked up this judge. By the way, the victims have expressed anger about this. The victims' families, one of the mothers was incredibly gracious and said to the defendant she hoped he could change his life around. But one of the brothers of another victim has expressed his anger at the sentence. And I think you would be hard pushed to find any victim of serious crime. Victims, by the way, include extended families because they're the ones living with the loss. Um, I don't think you'll find anyone that would favour shorter sentences. But anyway, I looked up this judge. Same judge a few years ago, actually, in refusing to jail a violent man who had poured bleach down his wife's throat as part of the abuse, actually claimed that she wasn't vulnerable. This attracted a lot of anger at the time, and there was a petition to get him sacked. Well, he's still in office. So I think someone like Richard Mansell QC is a disgrace. I think he needs to be immediately stripped of his office. But we can't do that. The public has no power over judges. Um, so I think the big problem in this country is judges are untouchable. The only way that they're held to account is professional misconduct. That is, for example, like I've said before, if they are, for example, messing around with a juror or they've perhaps, I don't know, been drunk during a trial or something, it's professional misconduct. There is absolutely no recourse, really, to hold weak judges to account. You know, you can write to the Attorney General and she can refer it to the Court of Appeal. The vast majority of those cases get ignored. I've seen it. I've seen the cases that get referred to the Court of Appeal, and it's minimal. So my question is, what power do the public have over weak judges? None. I think that's a disgrace, a total disgrace. Anyway, I'll round up this one, but I'm going to make a few videos about this. I'm going to refer to the other cases. I mean the other questions that I had.